M&T Bank versus Mongiello.
Good morning, Your Honors.
Good morning.
My name is Donald Scott. I'm counsel for the appellant, M&T Bank. We are here this morning on this appeal asking the court to reverse an order of the trial court denying a motion for rehearing following a non-jury trial which resulted in an order of involuntary dismissal. It's a very narrow issue, so I don't believe I'll have incredibly lengthy or overburdened arguments with it. It relates specifically to the non-payment of the documentary stamp taxes, which are due on loans that are recorded. I would ask that I be able to reserve 5 minutes.
Very good.
This is, as I stated previously, this is a residential foreclosure. It is based upon a note and mortgage which were executed by Mr. Mongiello to Colorado Federal Savings Bank in 2008. In February of 2012, the note and mortgage were assigned to M&T Bank, the appellant and the plaintiff in the underlying action. In September of 2013, there was a loan modification agreement which was executed by Mr. Mongiello and delivered to M&T Bank. Subsequent to that loan modification, there was a default in the terms of the mortgage. And
principal increase on the loan modification?
Yes, sir, it was.
So you're not contesting that stamps were due?
No, sir. It is undisputed that the taxes were owing on the loan modification agreement.
Why was it an abuse of discretion? The extra stamps on the modification?
Well, there's 2 points on that, and there's 2 points where it's an abuse of discretion. The one, at trial counsel relied on the Soma case, which described this very issue of where the document stamps were not paid. And it focused on the fact that this statute was not created for the benefit of borrowers or defendants in foreclosures. It is merely a mechanism to ensure that the state of Florida receives its taxes that's owing on negotiable instruments.
So you're contesting the remedy should have been different than dismissed?
Yes, sir.
So it didn't make a difference. Proceedings to put stamps on because you're saying stamps really weren't the issue in your case.
Well, what happened was, with the Soma case, the way that the court in the Soma case described it was there were 2 things that had to happen if a loan modification were presented and the stamps hadn't been paid on. And it was, 1, an involuntary dismissal, or upon a proper motion to abate the trial for a certain amount of time to ensure that there's sufficient time for those stamps to be paid.
And what was the amount of time that you told the trial court you needed?
He wanted immediately, but the trial court wasn't hearing it. He wanted to proceed. We're here for trial. Counsel for the defense said, was making we get one bite at the apple arguments, and we're here now.
Did anybody tell the trial court judge, we just need 15 minutes, we'll run down to the clerk's office, buy the stamp? I don't know if you can even buy them anymore because they're electronic now, but traditionally what would happen that I'm aware of is you say, Judge, yep, we messed up. We'll go down to the clerk's office, get it. Can we have 10 minutes? And you do that. That didn't happen.
With trial counsel, I don't believe he said I need a specific amount of time, but he specifically said we want to run and pay these taxes. And
so between the time of the order of dismissal and the original motion for rehearing, stamp taxes still weren't paid, correct?
That is correct, but that process was in place because there's a procedure for paying them delinquently, and that had been engaged by counsel for trial counsel for the appellant, and so shortly thereafter, those were paid in full, And those documents, which were, they're the official records that can be judicially noticed, were attached to an amended motion for rehearing that was filed, I believe, in March of 2017. So the trial court denied the
Your position is in the middle of trial, the court should have stopped everything to allow what ended up being a several-month period to get the dock stamp paid that should have been paid at the time the loan was made or the modification was made.
Yes, sir. There is a discretionary element here, and I'm sensitive to the court's concern about you're here for trial. This should have been done previously, and there is no explanation for it than mere inadvertence. But as I said, this was not a mechanism which was created as a defense.
I'm not sure. Mere inadvertence seems to me to be problematic. A lending institution generally knows what it's supposed to do. This seems to be more than mere inadvertence. This either seems to be calculated to save money or negligence, some sort of neglect. Mere inadvertence is we paid the wrong amount, or some assistant in the office did something wrong and they should have done procedure A, but they failed to. That's our standard procedure. There's no indication of the trial court as to why this wasn't paid other than, yeah, it wasn't paid. Well, in fact, the argument was, we don't really need to pay them.
No, I believe
I think there was some indication, there was some argument that it may not have been required to be paid.
Well, they're not required in all loan modifications do not require documentary stamps because a lot of times the unpaid principal balance and the interest rates and things are actually reduced. That's the benefit to a borrower sometimes receiving a loan modification, where here what happened was you had a loan modification that was used to cure a previous default, and there were additional monies that were owing now because of arrearages and perhaps escrow items, whatever, and the interest rates turned, and therefore the doc stamps were not paid. And I can't offer your honors an explanation in this specific case as to why that didn't happen. All I can do is concede the point that it was not. However, at the time for rehearing, when the court considered the appellant's motion for rehearing, the doc stamps had been paid, and it's an undisputed fact that they had been paid in full. And the case law that we brought to your honor's attention states that the statute is designed in that way to collect the taxes for the benefit of the state. And those cases acknowledge that those taxes can be paid tardily. And that doesn't render the instrument enforceable. Rather, it just merely means that a court, pursuant to the statute, cannot enforce the terms of it until they are paid. And because of the fact that this is not an affirmative defense, it's not any type of avoidance which can be pled by a borrower. This is merely to ensure that the state receives its.
Trial counsel took a different position, didn't it?
Yes, sir. So with that, we make the point that by the time we got to rehearing, the stamps had been paid. And the case law acknowledges that those stamps can be paid tardily, and that at that point the instrument was fully enforceable, and therefore because the court had before it a fully enforceable negotiable instrument that was only deemed unenforceable by machination of the statute, it should have been granted.
Does the statute give any discretion to the trial court, or is it silent as to whether or not you get to reinstate your action?
I believe the statute is silent as to that point. It merely states that it can't be enforced. The court shall not enforce. In response, the counsel for Mr. Mongiello and Mr. Mongiello have made the arguments that in addition to the arguments pertaining to the late payments of the doc stamps and the propriety of the trial court in denying the motion to abate, also may raise tipsy quotient arguments about I believe it was the actual loan modification itself, and the default letter and proof that it had been sent. As I mentioned, these were, and we addressed in our brief, that these were tipsy coachman arguments.
Assuming we do not agree that the appellee's lawyer stipulated that the proof of mailing was adequate, if we reject that argument, on an appeal from a non-jury trial, sufficiency of the evidence is subject to review without preservation, without objection. So what in this record establishes that, in fact, the paragraph 22 letter was sent?
The letter log.
How does it, tell me how that establishes that fact? I can't make it out, candidly. And there doesn't seem to be any explanation in the record as to what the codes and what that document actually represents.
No, sir. It was the trial testimony is silent on basically that testimony. The way that the trial went, as I read the record and understood, was that the defense's principal argument was upon the enforceability of this loan modification agreement. And there was a great deal of voir dire exchanges between the court and the witness regarding them. And in the end, the court basically informed the parties that believed that it was in fact unenforceable. At that point, the plaintiff, counsel for the appellant, put on the rest of his evidence, to which all of it was stipulated. There's a little bit of confusing.
There was no stipulation that the documents established that the letter was mailed. Do you agree with that?
The documents themselves, I would agree with that point.
Okay, so what supports or what establishes as a matter of proof that the notice letter was mailed?
Whatever the court can determine from the letter log. And if the
letter log has codes which nobody explains.
Yes, sir.
So what on that document do you look at and say, court, that proves it was mailed? Help us with that, because I'm having some difficulty with that.
Yes, sir. Traditionally, there would be testimony from the witness to translate those codes. And there's none. And there's not.
Okay. So it seems to me you're acknowledging the proof of mailing may be deficient. I'm not asking you to concede it, but there seems to be some doubt as to whether this record supports proof of mailing. Do you agree with that?
Yes, sir.
Thank you.
At this point, unless your honors have some further direct questions, I'd like to reserve the balance of my time.
Thank you, counsel.
Good morning, Your Honors.
morning.
My name is Latasha Scott. I'm with the law firm of Lord & Scott, co-counsel with the Stopa Law Firm. May it please the
Pull the
Court?
microphone up just a little bit.
May it please the Court?
Thank you.
Your Honors, just want to briefly touch on all of the issues that the Court found troubling. And to begin, I want to start with the Soma case that was argued at length at trial. And the Soma case is directly on point with the facts of this case and what actually happened at the trial. The Soma case says that there's no abuse of discretion by the trial judge if it dismisses an action where the lender fails to pay the doc stamp. Now, under Florida statute...
The court could have abated the action, and you wouldn't be able to prevail in this case either, because that was an exercise of discretion.
Well, Your Honor, the Soma case actually gives two options, and I kind of want to walk the Court through that in a roundabout way to answer your question. The Soma case says that where there is no evidence submitted at trial, and I'm quoting from page 304 to 305, where there is absolutely no evidence submitted at trial to prove payment of the document tax stamps, the lawsuit should have been dismissed. Now, the holding goes on to say, in an action to enforce the note, once the court discovers that the taxes have not been paid, the court must dismiss the action, or upon proper motion for abatement. Now, this court has said in the Rellinger case, which is 55 Southern 3rd, 638, that you don't favor abatements in the middle of a trial. In fact, an abatement usually emanates from a case where they're the same parties litigating the same issue in two different forums. That has nothing to do with the facts of this case. So I would say that an abatement was not even an option under the particular facts of this case. I think the judge did not abuse his discretion by involuntarily dismissing the case. So Soma says it must be a proper motion for abatement. And so I've just described what those circumstances would be proper. There was an ore tenus motion, Your Honor. We had no notice that they were going to ask for this relief in the middle of the trial. Now, Soma also walks the court through several cases and distinguishes remedies that would actually allow an abatement or allow situations where the bank could go forward with the doc stamp and continue with its trial, but those facts aren't here. For example, Soma goes through Klein versus Royale, 578 Southern 2nd, 394. In that case, there was a motion to dismiss. It was set for a hearing, and prior to that hearing, prior to final judgment, the doc stamps were paid. That didn't happen in this case. In Nikui versus J.P. Morgan Chase, the Soma court distinguished that case by saying the modification had actually been recorded on June 1st, 2007. The modification in this case was never recorded, but in the Nikui case, the court permitted the bank to go forward by paying the doc stamps because there was some effort to record that modification and pay those doc stamps prior to trial. That didn't happen in this case. In the first DCA, the Silber versus Jacksonville case in this 526 versus Southern 2nd, it also distinguishes cases where the lender is permitted to go forward, but that lender actually made some effort prior to trial to pay the doc stamp. In that case, the court allowed the bank to reopen their evidence and affix that evidence to the note to show that the doc stamps are paid. There is no effort like that in this trial. Now, this court has only said that with this particular issue that you can pay the doc stamps belatedly, okay? And that is not a reason to exclude the modification from evidence. There's no case directly on point from this DCA that talks about this particular situation. So that is why we argued at length so much. And so if you look at page 281 of the record, Your Honors, that is actually the modification. And at the upper left-hand corner, it says, after recording, return to M&T Bank. If they had actually recorded the document, usually at the top of that document, it'll be a book and page, and it'll also have the indication doc stamps and the amount of doc stamps paid. This modification was entered into in 2013. We didn't go to trial until 2016. So what I find troubling about this case is that we have an undue delay by the bank to comply with Florida law. The witness even confirmed that the modification had not been recorded and the doc stamps had not been paid. And in fact, as Judge Silberman was intimating, on page 70 of the transcript, lines 22 through 24, trial counsel said he was unaware that the taxes had not been paid. Your Honor, the judge actually said on page 72, he was troubled and said to trial counsel for the bank, I would suggest that the servicer had better look at these modifications in the future to make sure that they comply with the documentary stamp tax, because you're just going to end up seeing the same thing over and over again. Now, Your Honors, under these circumstances, how can we say that that's an abuse of discretion by Judge Baird? There was obviously a dilatory issue with bringing the motion to abate or even trying to pay the doc stamp. So I would submit that this judge did not abuse his discretion, and the court should affirm. Now, with respect to the motion for rehearing, there was a bit of discussion about that. And so my opponent said, well, there was evidence that we paid the doc stamp. Well, what they were looking for was a new trial. And the doc stamp information was just attached to a motion for rehearing. They should have had an affidavit and attached that, any proof of documentation. They just attached it to a motion. They could have also went ahead and proved that they recorded the modification and paid the doc stamps, filed a certified copy of that. That would have been self-authenticating. It was just months and months, another delay on how to actually complete payment of the documentary stamp. And that's simply not an abuse of discretion, even on the motion for rehearing. And Your Honors, there are two other issues that we've raised in our brief that says the court can affirm based on the Tipsy Coachman document. doctrine. And so we've briefed on pages 22 and 24 that there was no proof of mailing. And under this court's precedent in Edmonds, Allen, Judge Silberman, you've written Edmonds and Allen. Judge Badalamenti, you wrote Knight. A letter log is not per se proof that the letter was sent. There was no questions by the witness, by the bank's counsel, as to whether the log in and of itself proved the letter was sent. In fact, there was just a series of code numbers that Judge Silberman pointed out. There's nothing from the witness, in the record that shows what those codes mean. It's just a bunch of gibberish. And we did not, as you know, Mr. Stover does not stipulate too much in his trial. He certainly did not stipulate that the log showed that the letter was sent. That was the whole point in our Edmonds and our Knight cases where we argued that the log does not necessarily show proof of mailing. And lastly, the court can affirm, we argued that the loan modification, the original, was not present at trial. And while this case was pending, this court also issued the McCampbell opinion, which I filed a notice of supplement of authority on February 15th of this year, showing that if the original modification is not present at trial, then that is grounds for dismissal. While the remedy in that case was a new trial, we did file a motion for rehearing, Your Honors, and that's pending, and we're saying that the remedy should have been dismissal because McCampbell follows Radigan, and Radigan dismisses for failure to bring the original modification to trial. Now, lastly, there is no question whatsoever that the documentary stamp payment was required on this modification. My opponent said that there are instances where those are not required to be paid. First, that was not argued below. And second, this is not one of those cases. As Judge Vellante intimated and asked, this modification does increase the unpaid principal balance by $20,000. It increased the monthly payment. It changed the due date, changed the maturity date. That's all on page 281 of the record. And it's very clear that under 20108, subsection 5, that the documentary stamp tax is required on this modification. So, Your Honors, we ask respectfully that you would affirm the final judgment of Judge Baer. There is no abuse of discretion. The Soma case is directly on point, and we just thank you for your time. If you have any questions?
Thank you, Ms. Scott.
Your Honors, briefly, counsel's correct. There was no tennis motion. It was, as is in the record, trial counsel was unaware that the doc stamps hadn't been paid. There was no other way for him to raise that motion but by an or tennis motion during trial. The Soma case specifically, if you read it between the lines, is specifically saying that. It is dismissal or a proper motion. It's presumed that it's happening concurrently. You've got to do one of these two things right now. In this case, trial counsel moved to abate, continue, whatever word you want to apply. I think the counsel went with abate because that's the language that the Soma case used. But the point was he was trying to get a brief amount of time, or how much ever the court would allow him.
The question of abatement versus continuance is an issue that you
Thank
have to worry about. I think you have bigger issues to deal with in this case. One of the things you just said, which I'm not sure what to make of it, that counsel didn't know the doc stamps weren't paid. I don't dispute that.
Yes, sir.
But the loan modification does say to be returned after recording. Well, it wasn't recorded either. It seems to me somebody might have paid some attention to, okay, is this document valid? Is it enforceable? Why wasn't it recorded? Is everything done in order to bring it to court? And it looks like somebody failed to do that.
Yes, sir. As far as recording, the loan modification agreements are not required.
The document on its face says, after recording, return to so-and-so. So it is at least contemplated that it was going to be.
Yes, sir. I would concede that point. Yes. Do your honors have any additional questions?
We're good. Thank you, counsel.
Thank you, Your Honor.
Thank you. The next case is Alexander versus Allen and Hurdle Park.